Hi, everyone. I'm Donna Anderson, author of lovefraud.com and host of the True Lovefraud Stories podcast. Today, I'm speaking with Jolee Vacchi, a family law attorney who will explain how to protect your real estate in a divorce. In our most recent podcast called He Told Me He Was a Good Christian and Military Hero, a woman explained how her husband used her equity to invest in more properties. Then, even though he came into the marriage with nothing, in the divorce a few short years later, he got $4 million worth of real estate. Is this legal? And how can you protect your own property rights in divorce? Jolee has been practicing law for 13 years in Massachusetts and Rhode Island. 2 years ago, she founded her own firm called Foundations Family Law and Mediation Center. She is a certified coercive control trauma-informed attorney and also a certified mediator. Here's our conversation. Thank you so much for being with us today, Jolee.
I'm very happy to be here. Thanks for having me, Donna.
What generally is your approach to helping divorcing clients?
So I founded my own family law firm 2 years ago, and our philosophy is that we resolve family law conflicts as painlessly and peacefully as possible. Divorce is a tough enough transition on its own. And we, as attorneys, try to help our clients and their children move through the legal process as unscathed as possible.
Okay. Well, we know that's a tall ask sometimes, especially a high conflict divorce. So, but first, let's just talk about a typical situation, because what I'm trying to do is to present the listeners with an idea of what actually is normal, I suppose you could say, in a divorce, and then what can happen when things get tough. So, in a typical situation where a married couple purchases a home together and then divorces, what usually happens to the home?
But typically, in this situation, that both the deed and the mortgage will be taken out in both parties' names. And this means that both parties have an ownership interest in the property, and they also have financial obligations to repay any mortgage on the property. Upon a divorce, the property will can either then be sold and the net proceeds will be split between the parties, or one party can buy out the other spouse for typically one half of the equity in the home. And this typically requires the mortgage to be refinanced into the remaining spouse's name. So if both people were on the mortgage and one person's going to keep it, they have to refi the mortgage to just have one person's name on there. But nowadays, sadly, this usually means that there's going to be an increased mortgage interest rate because interest rates are a lot higher now than typically when people bought their home during the marriage. It could be 5 or 10 years ago.
All right. So, how might an abusive spouse manipulate this situation? One in which the couple purchased the home together, but how might the abuser try to take more control of the house and or the proceeds?
There's lots of different circumstances that can arise here. One situation would be if one of the spouses had premarital proceeds that they used to purchase the marital home. So in that situation, they're essentially taking something that's separate property and turning that into a marital asset. I've also had situations where an abusive spouse has taken a line of credit against the marital home without the knowledge or consent of the other party. So they're putting a lien and they're decreasing the equity in the home without their other spouse knowing. Also, sometimes there's not an equal playing field when it comes to financial transparency on the property. So sometimes, one spouse, they have all the login information and are responsible for making the payments. So I've had situations where if this were to happen, one spouse, they go and file for divorce and they find out, oh, well, the mortgage hasn't been paid for several months, or there's taxes that are unpaid. Sometimes the house could even be in danger of foreclosure, or there's liens that are on the home that the spouse wasn't aware of. So there's lots of different ways that an abusive spouse can unfortunately take advantage in these kind of situations.
So, what usually do you do in a situation like that where there's unpaid taxes, unpaid mortgage, or a lien against the property? How do you handle that?
Yeah, so that would all be determined in the final division of the marital estate. So not only are assets divided when you're getting divorced, but debts are also divided. And so I know we're going to be talking about the difference of community property and equitable distribution states, but depending on what state you're in, responsibility for those debts is going to be divided between the two spouses. So sometimes, I have had situations where a spouse didn't know about a lien or about, maybe a HELOC, a home equity line of credit that's taken out against the home, and the spouse who incurred that debt is responsible for it. But a lot of times, especially if it's a long-term marriage and both spouses benefited from either these loans or whatever it is, sometimes it is divided equally between the spouses. So there's a lot that goes into it. The most important thing is to try to stay as financially aware during your marriage as possible, because it can be a lot harder to try to fix it later on retroactively.
You did bring up then about separate and community property. Can you explain the difference between separate and community property?
Sure. So there's two ways that courts typically in the United States divide assets during a divorce. There's community property states and there's equitable distribution states. In community property states, assets that are acquired during the marriage are owned equally by both of the spouses. And this is regardless of who earned the income or whose name is on the title of any of the assets. If it was purchased or acquired during the marriage, it's assumed that upon a divorce, the marital property will be split equally 50-50. And some of the big states that are community property states are California, Texas, and Arizona. The rest of the states and most of the states, including where I practice in Massachusetts and Rhode Island, they are equitable distribution states. With these states, marital property is divided fairly, but not necessarily equally. And each state usually has a variety of factors that the judges have to consider when they are determining how to divide everything fairly. And some of those factors include, contributions to acquiring those assets during the marriage. And this also usually takes into account childcare and homemaking responsibilities, which is a good thing, as well as the financial needs of the parties after the divorce. One big factor is the length of the marriage. So in general, the longer the marriage is in an equitable property state, the more likely that things will be divided on a 50-50 basis. Now, when it comes to separate property, you mentioned with community property. So separate property is assets that are owned by one spouse prior to the marriage. So sometimes we call this premarital property. So it's what each spouse brings into the marriage before they become a unit. Another example is, gifts or inheritances that are acquired during the marriage. Oftentimes, these are designated as separate property as well.
So what would be an example of separate property?
Yep. So some other examples would be if, a husband owned a house prior to the marriage and then the wife moves in once they're married, that house would still be considered separate property, assuming that, only his name remains on the deed. If you have retirement accounts at the time you get married, any funds that you put into that 401k or IRA before you got married would be separate property, but the money put in during the marriage would be marital property. And then another example is an inheritance that's received during the marriage by one spouse. So from typically a family member, that would be separate property as well.
So how about if there one partner had the home originally, but then it was refinanced during the marriage? What would happen then?
So if a spouse's name is added to the mortgage of a premarital property through a refinance, that typically tells the court that there was, this is further evidence of intent that this property is actually co-owned by the parties. So you're essentially turning something that, was premarital property into marital property, because now both spouses are on the hook for paying the mortgage. They have financial responsibility for that real estate.
Okay, and you mentioned briefly about an inheritance, but what happens if property is inherited by either the husband or the wife?
Typically, that is considered separate property, but there's a really big caveat here that I think is important to note. Let's say, for example, a wife inherited $1 million from a long lost aunt. If she takes that $1 million and puts it into a separate bank account that's only in her name and just lets it accrue interest, or maybe she puts it in a CD or opens an IRA for herself, that's likely to remain separate property. If she were to get divorced, her husband wouldn't have an interest in that. However, if any of those funds, we call it, are commingled, it means basically mixed with something that is marital property, then that separate inheritance can be transmuted, another big word, into marital property. So my biggest advice is don't put in any inherited funds in a joint account with your spouse. Don't use the funds to make a big renovation on your marital home, because once you put inherited funds into a marital home, you can't like chop off that addition and pretend it didn't happen. It really, becomes a marital property characteristic now. So as long as the funds are separate, they should remain separate. It's just if they are mixed with a joint bank account or a marital asset that it could lose that separate character.
Okay, so now we'll get into some of the items that came up in our last episode, which was called He Told Me He Was a Good Christian and a Military Hero, which, if you've listened to the episode, turned out not to be true. But anyway, what happens when there are investment properties in a divorce?
So investment properties are treated similarly to how the marital home is treated. So either one party can buy out the other spouse's equity in that home and retain it for themselves, or those properties can be sold and the parties can split the proceeds. I will say that I have had some situations where some parties will decide together that they want to continue co-owning those properties because they want to continue to receive, the rental income from these properties. And if this were to happen, I would only suggest it if it's kind of like an amicable divorce or a cooperative or collaborative divorce. And there needs to be really detailed terms about how are the expenses of these investment properties going to be paid? How are the proceeds going to be split? And there definitely needs to be provisions about how and when those properties can be sold, because you don't want to be tied to your ex-spouse forever. And at some point, somebody's going to want to sell the property and move on. So that all should be detailed in a divorce agreement.
Wow. Okay. So anyway, back to the podcast that we came out with. In this case, the couple set up, or the husband set up, an LLC to manage the couple's property. So what does that mean?
Instead of the spouse, one or both of the spouses being named on the deeds of these real estate properties, I think she called them cabins, a business entity, in this case an LLC, was named as the owner of the property. So instead of, Patricia's name on the deed, it was changed over into the LLC's name on the deed. And people choose to have LLCs and business entities own properties, especially real estate, for various reasons. Some of the most common are for asset protection, privacy purposes, and potential tax advantages. So this is something that people do.
And how does the LLC then affect the ownership? I mean, who is the owner of the property then?
In this situation, the LLC is the owner of the properties. But with Patricia's case, she and her husband, I think we were calling him Jeffrey, she and Jeffrey were the co-owners of the LLC. So that means because the LLC owned the cabins, Patricia and Jeffrey owned the cabins. So what should have been Patricia's separate property, because she brought in, a marital home and some cabins into this marriage, she unknowingly transferred and made it marital property by putting them in the name of the LLC, which she co-owned with her husband.
And then the LLC, that might have specifications as far as like percentage of ownership. Would it be possible?
Yes. Exactly. Yeah. So when you create a business, you usually have an operating agreement, and it says, its responsibilities and also the benefits of each of the owners. And so if they were co-owners, which likely, most with married couples, it's usually 50-50. If they were co-owners and joint owners of the LLC, it means they each got 50% of all the LLC's assets, which unfortunately included all of that real estate.
Okay, so in the podcast, Jeffrey, the husband, leveraged his wife's equity, as he just said, to keep buying more properties. And then in the settlement, he got half the properties. So is anything about this illegal?
Unfortunately, no, it is not illegal. It's obviously extremely unethical. And, I'm sure a lot of people have some negative opinions about Jeffrey, including myself. But the moment that Patricia allowed the properties to be owned by the LLC, which he was a co-owner of, he had ownership rights in those properties. So it wasn't just his equity anymore, it was their equity, and they were able to sell them to purchase more real estate.
So in this story, Jeffrey, our perpetrator, targeted Patricia for her assets. So what would have to happen for this to be considered fraud?
So for fraud to occur, there needs to be a false representation that's made to induce reliance by the other party. So essentially, Jeffrey would have needed to lie in order to get Patricia to do something. Patricia didn't know what the consequences of her actions were, but there didn't seem to be any misrepresentation by Jeffrey about, the LLC. She knew she was going to be a co-owner with him. And so her, not having the education she needed isn't fraudulent. He didn't lie. He didn't make any make any misrepresentations. Also, fraud is really difficult to prove. The burden is on the person who's trying to show that the fraud occurred, and they need to have a lot of evidence to meet the standard that fraud occurred. And it doesn't sound like that happened here.
Well, how about though the fact that he lied about who he was when he married her?
That's pretty crappy. I mean, he definitely did everything he could to portray himself to be somebody that she was looking for, but it seemed like there was a lot of half truths to what he was saying. So, I know about his military background. It sounds like, he was in the Marines. That was true. I think she found out later on, but he didn't see, active duty and wasn't a sniper. So there were some half truths in there, but ultimately, I mean, that might have, fraudulently made her fall in love with him, but it wasn't relevant to, the LLC transfer or anything like that. She did that knowingly. And even if all of those things were true, it didn't have any effect on whether, she still was agreeing to let him be co-owner of the LLCs and the cabins.
So have you heard of one partner trying to bully the other partner into signing their property rights away?
So unfortunately, in a lot of divorce cases, there is coercive control and an imbalance of power dynamics that are present in these kind of romantic relationships. Thankfully, I haven't had any cases where one party has been bullied into signing away real estate property rights. But I have had, situations where perhaps, a vehicle has been, gifted or transferred over to a family member. And it does happen that a spouse's property rights are diluted, like kind of what happened to Patricia. She had, this was completely her separate property, and then it essentially got cut in half because of the business structure that she and her husband agreed to.
What happens if a sociopathic partner racks up debt? So how does that affect a marital property?
Yeah. So as I mentioned, in a divorce, not only are the assets divided, but responsibility for the debt is also assigned between the spouses. And typically in community property states and in a lot of equitable distribution states, those debts are shared pretty equally between the parties, especially if it's been a long-term marriage. However, there can be some exceptions if the debt was incurred only for the benefit of one spouse. And the most common example of this is student loans. Your spouse can't really get any benefit from your education. But I have had situations where, it's like I mentioned, if a spouse has taken out a line of credit against a marital home without the other spouse's knowledge, they could be responsible from that. It does get a little tricky though, because if you benefited from those funds, even if you weren't aware of it, the judge may still think, and they have wide discretion in family court, that you should share in some of that responsibility, even though, you didn't sign on the dotted line for the HELOC. A lot of times there can also be dissipation of marital assets, but a lot of times, unfortunately, responsibility from debt is shared pretty equally unless there's some extraordinary circumstances.
Okay, so if someone realizes that they're married to an abusive sociopath, what steps should they take before leaving or asking for the divorce in order to protect their property interests?
So there's a few things. Some states do recognize post-nuptial agreements. And so a post-nup is kind of what it sounds like. It's a prenup, but you sign it after you're married. And a lot of states do find these agreements to be valid, and you and your spouse agree on how you will divide your property if and when you were to get divorced or to die. But I would think that a abusive sociopath probably wouldn't be too keen on signing a postnuptial agreement, especially if this was their plan, like it seemed like Jeffrey's plan was with Patricia. I also think that it's crucial that you don't agree to any further financial transfers, no matter how enticing your spouse may make it sound. I know in Patricia's case, she mentioned, he was trying to wait for them to file until like November because they had a couple of real estate closings that were to happen. If she had, said, screw that. I don't want to go through with that. That could have, I know he ended up with $4 million at the end of the divorce, but I don't know how much equity was built in from those real estate closings. So it could have saved her some of the money if those, she had filed earlier. Also, the most important thing you can do is if you realize you are in this kind of a marriage is to consult with an attorney. All of this is extremely case specific. It, deals with the facts. Everybody's case is different. So just having a consultation with an attorney to know what your options are and to help guide you in your moves going forward is very imperative.
So, how about if you're already in the divorce? Is there anything you can do at that point to protect property rights?
Keep your funds separate. So don't put anything else into joint bank accounts. If you receive a gift or inheritance, like we were talking about, keep them in an individual account. Don't commingle with any joint accounts or use them to fix any marital assets. I also recommend consulting with a financial advisor, especially for financial literacy purposes, because like we were talking about, if one spouse used to handle the finances and you're not familiar with that, it's a whole vernacular and world that you might not be familiar with. You can educate yourself and speak with a financial advisor. And it sounded like with Patricia, she didn't fully comprehend the consequences of some of the things she agreed to. So if she had been a little bit more literate, it could have helped her in the long run. And also consulting with a forensic accountant can be helpful, because a lot of times these kind of abusive partners, they have hidden assets or they have things that are done without your knowledge. And you really want somebody to be able to get in there, review the documents, and get a whole picture of the financial landscape so you can make an informed decision in settlement negotiations or as you head into trial.
Which brought up one more question. Do you find you're a specialist in mediation? So does it work mediating with someone who's abusive, or is that almost a waste of time?
Yeah, no, I'm glad that you brought that up, because a lot of people assume that you shouldn't mediate with an abusive partner. And that makes sense, right? That seems to make common sense to us. But I will say it can work, and it can be very beneficial too, because abusers, one of the ways that they continue to abuse their spouse is through litigation abuse. So they can cause you to incur exorbitant legal fees because they're filing frivolous motions and burying you under discovery and paperwork. And so as an alternative to that, if you can keep control of the terms of your divorce within a mediation setting, that can save you a lot of time, a lot of money, and a lot of peace of mind, because this is only isn't it doesn't affect your financial bank, it affects your emotional well-being bank too. But if you are considering mediating with this kind of a spouse, I definitely recommend that you have counsel of your own that you can consult with. They can also attend the mediation sessions with you. That happens sometimes. We have both clients and both counsel present as well as the mediator. And you want a mediator who's familiar with abuse dynamics, not just physical domestic violence, like a lot, most people know about, but coercive control and manipulation and gaslighting. And when you're asking and interviewing your mediator, find out what kind of experience they have with these cases, what kind of safeguards do they have in place and protocols to try to, minimize that imbalance of the power dynamic between the parties. But mediation can be a really good alternative for these cases, just because it takes a lot of the power away from the abuser, and it actually puts it in your control. You're probably not going to end up with exactly what you want. Most people don't in a divorce, but instead of your divorce terms being forced on you by a judge or by your abusive ex, you're choosing what your terms are, and that's an empowering thing.
So, do both clients have to agree on who the mediator is? Is that how that works?
Yeah, yep. So mediation is a voluntary process, at least where I practice in Massachusetts and Rhode Island. So both parties have to, number one, agree to try mediation, and number two, they both have to agree on the mediator that's used. And the mediator is neutral, so they're not deciding who's right, who's wrong. They're not a judge. They don't have any decision-making power. They're there to facilitate the communications and try to help the parties reach their own agreements.
Okay. So, where can people get more information about your law practice?
Thank you for asking. So, my law firm is called Foundations Family Law and Mediation Center, and we practice in Massachusetts and Rhode Island. So, you can look us up online at foundationsfamilylaw.com. And that's also the handle for all of our social media, so Facebook, Instagram, and LinkedIn.
Well, thank you so much, Jolee. I really appreciate it. This was really informative.
Thank you. This is a lot of fun. Thanks, Donna.
I'm Donna Anderson, and this is True Lovefraud Stories. I hope you enjoyed this interview with Jolee Vacchi. For more information about her Foundations Family Law practice, please visit the page about this interview on podcasts.lovefraud.com. True Lovefraud Stories is produced by lovefraud.com. Engineering is by Terry Kelly. To learn how to recognize and recover from everyday sociopaths, visit lovefraud.com. You'll find articles, books, and webinars. You can also make an appointment with me, Donna Anderson, for coaching on how to recover from your personal experience with a disordered individual. Book your session today at lovefraud.com/talk to Donna. Also, I invite you to my Love Fraud Live YouTube show. I talk about how to spot, escape, and recover from sociopaths. And then I answer your questions. It streams live every Tuesday at 8 p.m. Eastern Time. I look forward to seeing you there.